Hi, everyone, and welcome to the SRHM podcast. My name is Nina Sun, and I'm an associate editor for the SRHM Journal. Today's episode features Rupsa Mallik, who's the Director of Programs and Innovation at CREA, a feminist international human rights organization based in the Global South and led by women from the Global South. Rupsa is in conversation with Na Yang, who is the co-founder and representative of the Center for Sexual Rights and Reproductive Justice, or CREA, based in South Korea. Together, they discuss abortion legal reforms by comparing India and South Korea's journey to advance safe and legal abortion. This episode builds on a commentary published by SRHM titled "The MTP 2020 Amendment Bill, Anti-Rights Subjectivity," which focuses on the Indian context. We hope you enjoy this episode.
Hello, everyone. My name is Rupsa Mallik, and I'm the Director of Programs and Innovation at CREA. Today, I have the privilege of speaking to Na Yang, the co-founder and representative of CREA and co-chair of the Joint Action for Reproductive Justice, a cross-movement coalition that successfully advocated for the decriminalization of abortion in South Korea. So a very warm welcome, Na Yang.
And hello. Thank you for having me. Hello. I'm very pleased to talk with you today.
So last year, I, along with several co-authors, had published a commentary on the Medical Termination of Pregnancy 2020 Amendment Bill, Anti-Rights Subjectivity. And the commentary really was actually a reflection and a critical analysis of the proposed bill that the Indian government had just kind of tabled in the Indian Parliament to amend the existing law. Since the bill was tabled, the law has since been passed. And in today's conversation with Na Yang, we are going to jointly explore abortion legal reform in the Indian and South Korean context, and particularly why we believe cross-movement alliance building and creating an inclusive agenda is vital to any process of legal reform or decriminalization of abortion. So Na Yang, I wanted to start by saying that for you and for many of your colleagues from the Joint Action for Reproductive Justice, April 11th, 2019 is probably a very significant day. It's on this day that the South Korea's Constitutional Court ruled that the ban on abortion was unconstitutional, and it mandated your legislature to revise the 66-year-old anti-abortion law. And of course, this has in a way paved the way for decriminalization of abortion in the country. So I really wanted to start by asking you, Na Yang, about the advocacy that you all did as part of Joint Action for Reproductive Justice. I think you all took this really path-breaking approach to decriminalization that really moved away from this typical pro-life versus pro-choice binary.
Yeah, last year the National Assembly failed to make an agreement for the amendment of the existing law. As you mentioned, as per the Constitutional Court's ruling of 2019, the criminal provisions on abortion in the Criminal Act is no longer effective from January 1st this year. So currently, termination of pregnancy is no longer a crime in South Korea. Here, my organization plays two leading roles in the reproductive justice movement in South Korea. One was building a network, and the other was leading discourse at the national level. In 2017, we launched the network organization Joint Action for Reproductive Justice. Since then, not only feminist organizations, but also many social justice organizations, including the Korean Confederation of Trade Unions, an organization of women with disabilities, LGBTIQ groups, progressive doctors organizations, and progressive political parties have formed a coalition of 31 initiatives. There is a precedent to this alliance. In 2010, the Network for Women's Rights to Decide Pregnancy and Delivery was formed, but it dissolved after 2012 when the Constitutional Court ruled against abortion. But as the Korean Ministry of Health and Welfare announced an amendment that would double jeopardized doctors who performed in terminating a pregnancy by listing surgical abortions as an unethical medical practice. Abortion was raised again and as a social issue in 2016. So we organized rallies and hundreds of people gathered in this protest. In 2017, more than 235,000 people signed the Blue House petition calling for the repeal of the Anti-Abortion Act and the legalization of medical abortion. And as a result of the continuous struggle, as you mentioned, on April 11, 2019, the Constitutional Court ruled the criminal provisions on abortion in the Criminal Act is unconstitutional. I think the important point that serves this momentum is when we decided to introduce the concept of reproductive justice and persuaded other women's organizations and social movement organizations to join forces under joint action for reproductive justice with intersectionality as our leading principle. Because we realized that the failure in 2012 was connected to how the campaign was framed on the binary of rights of women's decision versus rights of the fetus. We reviewed the historical context of population policy and the criminalization of abortion in South Korea. Then we moved viewpoint from fetus life versus women's decision to the necessity of social changes and the state responsibility to guarantee everyone's sexual and reproductive rights. Since 2016, our main slogan was, if abortion is a crime, the criminal is the state. We made this issue not about the problem of punishment and permission for women or special cases, but about everyone's sexual and reproductive rights. And we made abortion issues as issues about inequality, discrimination, and injustice in historical and socio-economic context. We emphasized that responsibility of the state and shifted this point from individuals to the state, society, and the public system. Co-founders of CREA, who are lawyers, doctors, researchers, and activists, wrote a book together dealing with abortion issues from historical, legal, religious, medical, eugenic, and sexual perspectives. This was effective for making other organizations to join this issue and for persuading the media and judges of the Constitutional Court, I think. Yeah.
Thank you so much. To me, on another note, really remarkable how little globally within abortion rights advocacy we talk about and learn from some of these really important experiences and journeys that countries are going through in Asia. In particularly, I feel Asia, we really are less visible. I mean, everybody's talking about Argentina and Poland and Ireland.
Yeah,
Isn't it? In India, on the other hand, we've had a very kind of a different journey that's really not been embedded within a movement building approach. I feel like even today, 50 years after abortion was legalized in India, of course, many movement actors and advocates have come into the space to advocate on this issue. It remains primarily lodged within a public health discourse. And often the law as it stands today is really seen as this vehicle through which we can bring about transformative change. And we, of course, know that the limitations of these laws, because, in India, abortion still remains criminalized under our Indian Penal Code. It's just that this abortion law, the Medical Termination of Pregnancy Act, just creates an exception. So therefore, it remains very provider-centric. Really, it's really the state deciding for individuals and pregnant persons when, how, and under what conditions you can seek abortion. So in that sense, the journey in South Korea really is a remarkable journey of how does one build a movement around advocacy for legislative or policy change. And, just to share with you, Rina, Nayang, that, when last year the government, went ahead and suddenly tabled these amendments, we were all caught unawares. Firstly, we were in the midst of pandemic. And on top of that, there was hardly any consultation. The government was really opaque in the way that it went about. And there were some really important provisions, on the other hand, that got introduced, which was about extending the legal limit, which was currently 20 weeks to 24 weeks. But interestingly, only for what they call certain categories of vulnerable women. Talked about establishing medical boards, third-party authorization that would grant sort of permissions. A lot of those provisions also relate to issues of disability and abortion. And as you know, that's really a kind of a problematic and contentious domain. So just to say that, just listening to you and the way you all went about it, I think there's so many important lessons that civil society actors in India can take from. But just to kind of build a little bit on the Indian and South Korean experience, I think for Korea as well, as recently as 2010, and you've shared this with me when we've been talking about these issues, that it wasn't really a feminist agenda. And both countries have these very long historical sort of context of anti-natalist policies, and within which really contraception, mainly sterilization, and even to a large extent abortion were freely available for certain people, right? Even though in another level, abortion remains criminalized. So what I think would be wonderful to hear from you, and also because I think so little is known about some of these country contexts like South Korea, like a little bit of the historical context of how really the issue of advancing safe abortion and abortion rights really became a priority for feminist groups since 2010. And what were those shifts? And were you all successful in a way in shifting a sort of a very deep-rooted narrative that remained very embedded within anti-natalist policies to one which today, from what you just shared, sounds is really a very movement-based, inclusive sort of approach and ecosystem. So really, Nayang, would love to learn more about that, because I feel like between India and South Korea, we do share this history, and it would be interesting to hear a little more about the South Korean context.
Yeah. Oh, yes. As you mentioned, in South Korea, the issue of abortion has not been an important feminist agenda till 2010, because the South Korean government pushes anti-natalist family planning policy very forcibly during the 1970s and 1980s. So abortion was actually accessible, but there were still problems related to the actual practices of abortion, which deeply reinforced the stratified reproduction system. They induced only useful and productive citizens to have their children. For example, the government offered strong incentives such as public housing and health insurance benefits to families who had less than 2 children. But people with disabilities, single mothers, and poor mothers were often subjected to forced abortions. The Mother and Child Death Law, which the dictatorial government made to push population control, justified that. The first and the second provisions, which allow abortion in the Mother and Child Health Act, are about people with disabilities. And it was not about fetuses. It was about parents with disabilities. So especially many women with disabilities and women who have transmissible disease were forced to have an abortion without their agreement. And the government has controlled women's sexuality using criminal provisions, and at the same time, on the other hand, has controlled unproductive lives by restricting the reproduction of people with disabilities and other social minorities. Korean society has dealt with abortion of married women as avoidable matter. But for unmarried women and especially for minors, it has been considered as problems of their irresponsibility. People with disabilities, single mothers, poor and sick mothers were often subjected to forced abortions or forced to give up their children for intersectional adoption. These policies were very useful to the government, not only with population control, but in achieving economic development. Abortion was a very common experience for many Korean women. Women who have experienced abortion tended to hide their experiences because of social stigma, not because of the law. So it was very hard to gather women who speak out about their experiences. The co-founders of SHARE first met in 2015, just 1 year before the abortion issue re-emerged in South Korea, when the organization Women with Disabilities Empathy initiated a research project to review the history of the criminalization of abortion in South Korea. When we realized that we had to acknowledge, address the forced sterilization and abortion of women with disabilities. And we revealed that the South Korean government had not protected both the rights of women or the lives of fetuses in their population policies. I think that the exact point of the reason we should struggle for reproductive justice instead simpler frame of rights to abortion. As I mentioned before, we actually had the same strategy with other countries, like we'd like to expand legal grounds on abortion, but we changed our mind from this moment. I think the most important point is that the punishment permission frame cannot solve any social problems and injustice related to abortion issues. It is only strengthening discrimination by distinguishing the values of life. The state makes us to misunderstand problems related to discrimination and injustice as problems of individual qualification through punishment permission frame. By so doing, the state successfully avoid from their responsibilities to solve social injustice and discrimination. Everyone has their own socio-economic context and is mostly very complicated. These things cannot be summarized or simplified on some ground. The same goes for decisions about the life of the fetus. The same goes for decisions about the life of the fetus. If the state has sincere consideration about life, they should take their role in solve social injustice instead of the punishment permission frame. The role of the state is to strengthen policies to ensure the living of people with disabilities, not about whether they allow abortion of fetuses with disabilities. The punishment permission frame maintains discrimination onto social status. So we urge the government to repeal any forms of punishment against abortion and endeavor to ensure people's rights. This is a Korean historical context, and I'd like to know some details and historical context of legal and social status of abortion in India as well. Rupsa, can you tell me about more about your context?
Thanks so much, Nayang. And I think the nuance and sort of the strategic shift that you all made and around this thinking about how conventionally we've kind of looked at this issue of punishment permission as this framework. And, a lot of our attempts to reform laws have been within that frame, and how you really moved away from that to really look at it, larger issues of social justice, issues of discrimination, and really argue that we cannot look at abortion in isolation, but really within that frame. And that's when you can see real transformative change in people's lives. And I think the other thing that really stood out for me is just this idea that pregnancy, unintended pregnancy, and experiences of pregnant persons is just so diverse. And it's just wonderful to hear that the first step, in fact, in this journey was by an organization of persons with disabilities, which is just so rare and unusual. Because honestly, in most of our countries, and I'm going to just share with you shortly a little bit of our Indian journey, which has been fast different, I can tell you, from the South Korean journey, is like it is just impossible to bring in that kind of intersectionality and diversity. So, to your question, Nayang, I think there's much that is similar in terms of our journeys. India too, post-independence in the mid-40s, has had a very explicit sort of antinatalist population control policy, driven by sort of this idea that without controlling the population, India could not develop. And of course, we know that was very much the global development sort of rhetoric of those days. And very much a part of that package was not only this over-reliance on sterilization, but also kind of this idea that abortion in some ways could serve to facilitate those larger issues of the government. And even though abortion was criminalized in the early 70s, India did go ahead and legalize abortion in a way to create an exception for certain categories of women to be able to access abortions. And really, it was very much something that was, kind of a vision of the state, who, where, and how you can get an abortion. It wasn't about rights. Some argue a large part of that decision to legalize abortion in the early 90s was really a part of this extension of this antinatalist sort of policy that the government was practicing at that time. And of course, there is literature and archival material from the debates that were had in Parliament at that time, where also I think there was huge concerns about the number of deaths from unsafe abortions due to septic abortions. And so I think it was a combination of factors, for sure. I have to say, since the 90s, and we know this, since the International Conference on Population and Development, many of our governments, and I think globally, a consensus was built around moving away from these sorts of anti-natalist policies as the bedrock of programs on, let's say, family planning, maternal health, and really kind of embracing the larger sort of vision of sexual and reproductive health and rights. But one thing I feel, Nayang, in both South Korea and India, because the history of antinatalism has been so long and so deeply embedded in our policy, in our structures, in our institutions, and I would argue even in the way that our providers, the sort of provider bias that is so deeply rooted over decades, that moving to a more expansive, rights-based approach in the way one then thinks about provision of abortion services has been difficult. That's one. Two, I think in India, this is moving away a bit from the court conversation, but really I think the 70s and 80s in India and the women's movement was very much around looking at issues of violence. And of course, there was transformational work done, and which led to a lot of laws and, highlighting that issue. Abortion somehow never has been a core feminist agenda. And I would say even till date, I do not think it's really core to the larger women's movements issues and agenda. Certainly we have a whole new generation of younger activists who are doing much, I think, to, on the other hand, really visibilize the issue, talk about issues of stigma. So you're seeing a very different kind of engagement. So in that sense, I'd say when this opportunity kind of presented, last year, when the bill was tabled, like I said, we were caught unawares. Several provisions of the bill, and because you talked a lot about this whole issue of how persons with disabilities and this whole issue of disability testing, abortion is looked at, I think one of the most important provisions in these amendments is exactly this extension of the abortion limit to 24 weeks and beyond. but only on the ground of fetal anomaly. And therefore, for someone like me, and at CREA, because we've done a lot of work at this intersection of disability and abortion, straight away, it was a red flag. A red flag not because we believe that individuals who are pregnant and need an abortion should not have the decisional autonomy to decide on whatever reason or grounds, but that's exactly that, right? It's the individual's right to choose and decide. That's not something we contest. But when a government is creating a law with this sort of an exceptional kind of approach to saying, okay, we consider only pregnant persons who have a fetal anomaly as the only ones meriting this right to having abortions post 24 weeks, then it's a different kind of message, right? Because after all, abortion today is a very safe procedure. If somebody can actually have a permission to have an abortion on the ground of fetal anomaly as at 24 weeks, many other women who've had severe change in circumstances should have the equal right? But you're setting up this idea of two things. What you were highlighting, this idea of what are these productive lives, and therefore this image of this healthy fetus, whatever that means in the vision of the government. And then there is this other idea of certain people who are in fact seen to be these citizens who therefore are contributing to the economy and development and therefore should produce children. And of course, we know, as you rightly said, that women's sexuality, women's autonomy, women's decision making have always been the one which is controlled. And it's all the state and the government that kind of through laws and policies have been constantly doing it. So I really honestly feel, Nayang, at least for me, because for so long we've seen only the law as the vehicle through which we can expand this idea of improving access to safe abortion, that we really need to move beyond that. I really feel the law can only, exactly as you said, the way it operates as this kind of framework of punishment and permission cannot bring about transformative change. What you all managed to do, I think, is really then embrace not just intersectionality, but inclusion of a wide range of people who will be part of this conversation, which sadly in India, on the other hand, remains very much about that majority, and that majority being heterosexual married women, who of course are the largest numbers of women who are seeking abortions, right? Annually, we have, according to a Guttmacher Institute research a few years ago, something between 14.5 to 15 million abortions. And of course, we can safely say probably a majority of those are exactly women of a certain age group, married, heterosexual. And so, I think feminist advocacy, our imagery of who is this person deserving of rights tends to kind of attach to this vision of this certain kind of women. And therefore, you are leaving out and excluding so many other diverse experiences. And I think particularly for me, what's interesting is this whole bit that you've shared on this axis of disability and abortion and sort of the inclusion of persons with disabilities, because I do think that really in some ways, in my view, remains kind of the final frontier of what we need to shift in our feminist and SRHR advocacy. Of course, it's very challenging. It is very complex. It's very contentious, not least because of the co-option by the anti-rights, anti-gender folks of the disability issue to advance their agenda, let's put it this way. But we've got to deal with it head on, right? If we don't, then somebody else does, and it's often not necessarily to advance the rights of persons. As you rightly said, this is not about whether a fetus has the right to be born or not. It is about what are we doing about the rights of a certain constituency that's equally deserving of these rights. So I just wanted to circle back finally, Nayang, for you to maybe dig in a bit more on this whole issue of disability and abortion and some of the sort of rich experiences that you kind of garnered through the joint action for reproductive justice, because disability organizations were so much a part of that journey. So maybe over to you now, Yang, to share a bit more.
Yeah. I absolutely agree with you, especially you mentioned about people have very different backgrounds in their own context. And I'm very happy that we can share now, especially Asian context, historical context, especially. As I mentioned above, I heard many experiences of women with disabilities. We heard many experiences of women with disabilities. The women were pushed to terminate their pregnancy by their family members or by staff of facilities where they live, and the government actually induced that kind of practice. So for some women with disabilities, giving a birth was proof of their ability as a mother and as a woman. But even if they keep their pregnancy after they persuade their family members and doctors, if they delivered a baby with a disability, they could not avoid blame. Some doctors pushed them to try very expensive and experimental medical techniques. On the other hand, during the 1970s and 1980s, some women who had more than two children were forced to have sterilization surgery. When we launched Joint Action for Reproductive Justice, we gathered and announced those experiences through our performance. We linked these kinds of experiences with various abortion experiences, such as an experience of sexual violence survivors, sex workers' experiences, and experiences of teenagers. And we also had a non-binary transgender speaker. For migrant women especially, it is very hard to reveal their abortion experience publicly because in the case of married migrants, their qualification of stay depends upon their Korean husband. So many migrant women push to pregnancy or abortion by their Korean family members. Giving birth to Korean baby is also related to their naturalization requirements. Supporting policies are focused on childbirth and child rearing. Translation and interpretation are also barriers. If migrant women give birth to other migrant men's children, their children cannot properly be documented in South Korea. So migrant women are helping each other by their own ethnic networks. Whenever we have press conference, released statements, and suggested alternative law and policy, we always reflected intersectional experiences of various and marginalized groups. And now it's very helpful to our next step of decriminalization and to improve our strategy for reproductive justice. We still have many challenges. Conservative parties and anti-choice groups are still endeavoring to revive the criminal provisions, and the Korean Society of Obstetricians and Gynecology and Korean Association of Obstetricians and Gynecologists are urging the government to allow consensual objection. Now we are focusing on building a public system that guarantees our rights and provides comprehensive services, including healthcare, education, and other social services. First of all, we are urging the government to allow mifepristone and to put abortion care in national health insurance coverage. The government should announce that abortion is not a crime anymore and will be treated as a medical services. It is very important to eliminate stigma and encourage medical professions to help people who need abortion services. And the government should urge companies to guarantee abortion leave and should ban disadvantage or discrimination on the grounds of abortion in companies and schools. We need to link social services like comprehensive information, translation services, foreign language, and sign language interpreter, personal assistance, and other social welfare services to support social minorities such as women with disabilities, teenagers, migrants, and refugees. CREA announced a framework on the guarantee of sexual and reproductive rights and proposed this to members of National Assembly. We also published safe abortion guidebook for counselors and medical professions. The book is called Together by Your Side. Joint Action for Reproductive Justice is now conducting fact-finding and policy needs surveys on experiences of abortion. We have a presidential election next year. Currently, some candidates and some members of National Assembly have interest in the Framework Act on the Guarantee of Sexual and Reproductive Rights we suggested. So we will keep pushing this draft to them and will make substantive changes in public systems and policies. We're keeping fighting against an attempt to restrict our rights and keep moving forward to extend our rights now.
Thank you so much, Na Yang. I'm just so thrilled that we could really, through this conversation, share this absolutely outstanding sort of journey that you'll have had in this last decade or more in shaping sort of the advocacy, the discourse, and to kind of advance decriminalization of abortion in South Korea, and have successfully done so. I think it's really important for many of us working in different country contexts to learn about these experiences and see what we could do in our context. And I also really appreciate that you shared a lot of very concrete recommendations in the way that not only can we bring about, let's say, changes in laws or let's say kind of a social perspective, but also really concrete strategies of practical things that we need to demand for. And I thank you very much for sharing some of that with us. It's been really a fantastic having you here, Na Yang, and hearing the South Korean journey. And I hope you found some of the issues that I shared about the Indian context interesting as well. And I hope we can continue this conversation beyond this podcast into actual kind of ongoing collaborations over the years. So just a very big thank you to Na Yang. It's been a pleasure talking to you.
Thank you to Rupsa Mallik and Na Yang for this insightful conversation. To read the article co-authored by Rupsa on India's abortion reforms, visit srhm.org. All articles are available online and free of charge. For links to other resources discussed by our guests, please see the episode description. If you would like to submit an article to SRHM, visit srhm.org for more details. Every year, we publish 2 theme issues, as well as an open issue which currently includes a special collection of research articles on the impact of COVID-19 on sexual and reproductive health and rights worldwide. Follow SRHM Journal on social media or sign up for our newsletter to receive notifications for new research. Thank you for supporting the SRHM podcast, which is produced by the SRHM staff. The music was composed by Tiber Christian and Salomon Botond.